Good morning, good morning.
Morning, Tatupala.
Is my video sharp?
Yes, it is clear.
Is clear?
Yes, sir.
Oh, thank you very much. At least there's improvement. There is some
Yes, I do. Can you hear me? Okay. Recording in progress.
Good morning, honorable members and colleagues on the platform. It's 10 o'clock on the dot and the meeting is about to start. We have our agenda before us, of which the process is about public hearing on Immigration Amendment Bill 2024, National Assembly Section 75. The agenda before us, it goes as follows. It will be chairperson's welcome and opening and remarks, an outline of the session, and then we would have presentation from Mr. Enoch Mbau, Mr. Stembiso Lamont, University of Cape Town Refugee Rights Unit, Ms. S. Sayeda, and Mr. Sky Kruger, and then would have lawyers of human rights, Ms. Nyeleti Baloyi, and get as well the presentation from Scalabri Center of Cape Town, Mr. James Chapman, and as well we'll get the department response to submissions, Advocate Malakate, and Office of the Chief State Law Advisor and Parliament Legal Services to comment, and then would have committee discussions, and there will be my remarks at the end of the session. So without wasting time, members and those who have joined us from the public, I want to welcome as well the PMG because we know they are always with us on the session. On the 29th of October, 2024, the committee received a briefing from the contact advisor on the summary of submissions on the Immigration Amendment Bill. The committee then undertook a public participation role since invited those stakeholders who wish to make oral presentation to the committee to do so in today's meeting. We all know, members, that this is part of the whole process that we have undertook in terms of public participation. In the written submission, some key issues included capacity constraints within departments, the need for regional cooperation, the need to clarify the interest of justice, reasonable conditions, and relevant factors contained in the amendment bill, the need for interpretation services and legal aid, and to distinguish between illegal immigrants and asylum seekers, among others. We will be receiving oral inputs from the following 5 commentators today, those who have indicated through public participation that they are available for oral session. Mr. Enoch Mbau, as I said, Mr. Stembiso Lamont, a 15-year-old school learner who we appreciate that he did understand the role, the citizenry role that he needs to play in this country. UCT Refugee Rights Unit, and as well Lawyers for Human Rights, Scalabrini Center of Cape Town as well is present today, of which one of those that we could have scheduled before. Members would know that Ms. Chele then withdrew because of her unavailability. So hence today we are only standing at 5 people that would be doing oral response. We welcome both the individuals and the organizations, and we are eager to listen and to engage around your inputs. After the oral representations, we will receive a response to the submission from the Department of Home Affairs, the Office of the Chief State Law Advisor, and Parliamentary Legal Advisor. We welcome everyone to the meeting, and we were sure it will be a fruitful engagement on the Immigration Amendment Bill. Members, you would know that this matter that is coming before us, it is based on the fact that it was sent back by the Constitutional Court for amendment because it didn't meet constitutional requirements. So hence we had to take the whole process back to public participation for input up until today. And we hope that our participants will be participating freely so to ensure that we shape this immigration bill to accommodate all human rights factors. Without wasting time, I would want to introduce members of parliament that are with us in the midst and our support staff. Today we have Honorable Billy from KZN, who is representing the DA. And we have Honorable Midupi from Northwest, who is representing the ANC. And we have Honorable Mukai, who is representing the DA from Northern Cape. And we have Honorable Nonkonyane, who is representing the ANC from the Eastern Cape, and as well the whip of the select committee. And we have Honorable Noe from the Free State, who is representing the ANC, and Honorable Commander Phala from the ANC, who is representing Limpopo. And we have before us as well Honorable Zulu from Mpumalanga, who is representing the MKP. Then we have Honorable Mampuru from the EFF, who is representing Gauteng. Those are the members before us on the platform. And we have then in terms of our support staff, before I go to support staff, I nearly forgot, we have Honorable Gotzel from the Western Cape, who is representing the DA. Those are the members of the select committee before you. And we have our support staff. One is the second secretary, Ms. Buselwa, and we have our content advisor, Dr. Anthea, and we have Enrico, who is one of the people who are assisting us, supporting staff in terms of logistics and other support. And we have Ms. Lulekwa, who is the PA for the chairperson of the select committee. So for those are members from our side and our supporting staff. With that being said, I've already acknowledged the PMG on the line, and as well the public members who have joined us, and those who will be presenting before us. I want to declare this meeting officially opened with all the opening remarks that I've made before the committee, and as well those who have joined us from different organizations and individuals. With that being said, I would now move to our second secretary for apologies that are before the office. Over to you, Buzelwa.
Thank you, President. Morning, members and our guests. Our apologies are as follows. We've got the apology of the minister and the deputy minister. They've got the prior engagement. And then we've got the apology of Honorable Ferris. He is off sick. Thank you, sir. That's all of our apologies.
Okay, thank you, Ms. Busela. Members, I just want an indication if I'm audible, because on my side, I hear there's a background of an echo. So can one member just indicate if I'm audible and there's no disruption?
Chair, we can hear you loud and clear. I can hear you, Honorable Mukai.
Okay. No, thank you, Honorable Mukai. And then at least you are giving me some certainty that I can continue. With that being said, members, Wizela, can you flight back the agenda so we can continue with our work? We really appreciate, as the select committee, the work that has been done by the public and as well members from different organizations, because this shows that people do take the South African agenda serious in terms of ensuring that everything works better for the community and the services at hand. We want to really appreciate, we have went through your presentations and we were able to actually classify in terms of where can your submissions be fruitful and meaningful in terms of the work that we are doing. So without wasting time, I would now call it 10 minutes past 10 on my side. We are on time. I would now call Mr. Enoch Mbau. Before I hand over to you, sir, I just want to indicate how we work. When you are given a platform, just open your video. If you've got connectivity issues, you would indicate, then you would switch off the video, but continue doing your presentation for 10 minutes as on the agenda. All members are supposed to be doing that. When you speak, you would open your video and your mic as well. When you finish, because of your time, it's only 10 minutes, you would then switch off both your mic and your video. This platform is only for those who will be doing oral sessions and as well members and the department and the Office of the Legal Advisor. It is not open to the community for participation, but they can follow through the conversation and as well take note of where we are in terms of making sure that this immigration amendment bill is a fit for purpose bill for South African at large. Over to you, Mr. Enoch Mbau.
Thank you very much, Jane, as well as also everyone that is in this engagement. Greetings to the chair, greetings to everyone. Today I come to you as a layman. I come to you as a patriot and a child of this country. The reason for me sending my submission, I think I wanted to discuss a couple of points, which are mainly challenges with identifying and tracking illegal foreigners, the strain on the judicial system, as well as broader socio-economic burden and the erosion of immigration officers' authority in light of this bill. So with that said, as I mentioned, as a patriot, I notice and I understand the bill that seeks to amend Section 34. While I acknowledge the intent to align the Act with constitutional principles, I respectfully also am concerned about its implications for immigration control, national security, and public resource. We as citizens, we as everyday people fall victims to these consequences every day. Therefore, I speak from experience and everyday observation. To start with the first point, when I say challenges with identifying and tracing illegal foreigners, the proposed requirement that every illegal foreigner be brought before a court within 48 hours is not achievable and also a little bit insensitive. In most cases, illegal foreigners have no fixed address, no variable or verifiable identity documents, and in most cases, no reliable means of contact. Many may also, if they do possess any, have false or fraudulent documentation, and this makes it difficult for authorities to then find them in the event that they are released. Now, the bill's provision for conditional release based on the interests of justice, which I support should be well defined in the bill, could also facilitate evasion. And with that said, people that are untraceable would then be difficult and would be aided by the state to evade. The second point, which is the strain on the judicial system. I think we can all agree and understand that our courts are already heavily burdened with criminal and civil matters, requiring automatic court appearances for each and every immigration detainee within 48 hours will place an unrealistic administrative and financial strain on the justice system. The focus, I think, should remain on efficient deportation instead of creating another layer of bureaucracy that further delays enforcement actions. The third point and concern that I had was one for the broader socio-economic burden. Now, this burdens all South African citizens as well as legal immigrants that are in the country legally. Illegal immigration places significant pressure on South Africa's public health, education, as well as social service systems, which are already, we can all agree, are overstretched. Now, a system that allows for prolonged legal processes and a potential release of an undocumented individual will, I think, exacerbate these pressures, diverting the limited resources that we have from the citizens, lawful residents, and legal immigrants who depend on them. I think it is unfair on all of the individuals that I've mentioned, which are our citizens, as well as lawful residents, that they are to suffer at the hands of this bill and the related sort of effects. My last point and concern was one of the erosion of Immigration Officers Authority. I think the bill diminishes the operational authority of our immigration officers by compelling them to justify each detention and to consider the interests of justice, which again I agree should be well defined. Now, if they are to consider the interests of justice before acting, I think in practice it is almost impossible. In practice, being present in the Republic of South Africa without a legal status on its own should be sufficient grounds for detention and deportation. Immigration officers are trained and authorized under existing law to enforce these provisions. And I think that imposing additional procedural hurdles will slow down enforcement and encourage non-compliance with immigration laws. Now, I took time and I read a study in the African Renaissance, volume 21, number 4, which discussed which aimed to discuss technological devices and the detection of illegal immigrants. It was a case study of the eThekwini municipality in our republic. The study employed a qualitative research approach, utilizing both focus groups as well as individual interviews. The key actors that were interviewed, they included the members of the SAPS, the South African Police Service, as well as the Department of Home Affairs, community policing forums, as well as urban improvement precinct and safer cities department. The findings of this case study underscore the urgent need either for us to modernize or South Africa to modernize our immigration enforcement mechanisms or to ensure that we employ stricter immigration and deportation rules. Now, to close off, my recommendations would be as follows. One, I would urge the Parliament to consider the following additions. One, to provide immigration officers with greater operational discretion and to prioritize swift deportation processes over instead of choosing prolonged judicial reviews that serve little practical benefit to the everyday person. The everyday person is affected by crime every day, and it is better to account for people that we can account for as a republic. South Africa is a sovereign state that must balance the constitutional rights with national security and economical stability. Legislation must not unintentionally weaken immigration enforcement or incentivize irregular migration. And most importantly, I think it is important that we put South Africans and its lawful citizens first. Thank you very much.
Thank you, Mr. Mbau. And one would want to indicate to you that you're within your time. You even left 2 minutes, which is good. But you can, if you feel that there's something that you could have left out, you can just use that 2 minutes to finish.
Of course. Thank you very much. I don't think that there is anything out of nerves that I can remember that I left out. However, I think, again, with the reading that I've done, I can stand behind the definitions that we require, such as things for interests of justice, as well as also use of the word court in the bill. And I think those are things that will shape how this bill will sort of support us, as well as also illegal immigrants, to ensuring that their safety and health is also still well looked after, regardless of their status. I think that is all from my side today. Thank you very much.
No, thank you for actually playing your citizenry role. And we hope many will learn from you that it is important to make inputs when such processes are unfolding. Now we'll go to Mr. Stembiso Lamont. Your time is 10:20, so you must be within your 10 minutes. Over to you.
Greetings, Chairperson and members of the Select Committee. Thank you for giving me the opportunity to address the committee today as a citizen and a child of this country. My name is Temso Lamont, and I'm a student at Pretoria Boys High School. I am here to ask that the decisions made today help create a fair and secure future for everyone in South Africa. Chairperson, immigration reflects who we are as a country due to the policies that we enforce. The immigration policy shows how we balance security, compassion, and opportunity. It shapes our economy, our communities, and how people will remember our country. I believe that the Immigration Amendment Bill B8B of 2024, it comes at an important time, Chairperson. It's trying to fix real problems we see every day, things like people living here without legal documentation, long delays in getting permits, and corruption that hurts everyone. Immigration control has a clear purpose to keep our country orderly and secure, but we cannot forget about protecting everyone's dignity. Our constitution tells us that's just as important, and it's something we should always keep in mind when making decisions, Chair. Everyone has the right to food, water, and medical care under Section 27, and Section 10 guarantees the right to human dignity. Chairperson, the word everyone within those sections is crucial because it refers to everyone and not just the citizens, but it includes immigrants to whom the bill is intended for. Our borders, humanity, and Ubuntu values should be safeguarded by our laws, Chairperson. I speak the fundamental human rights of refugees and asylum seekers must be safeguarded by the bill. Many people travel to South Africa to escape extreme poverty and persecution, violence, but they must wait years, Chairperson, for their applications to be finally reviewed. They frequently lack access to healthcare, education, and even legal documentation. I had read up on a case of in Center of Child versus the Minister of Basic Education in 2000. And the judge within that case confirmed that even non-citizens and undocumented children also have socioeconomic rights. While they wait for the applications to be processed, I believe that the bill should guarantee that asylum seekers have access to basic services like healthcare, education, and legal assistance. If the government collaborates closely with NGOs like the UNHCR, this can go more smoothly, Chairperson, honorable members. In recent weeks, we saw Operation Dudula trending for blocking healthcare to migrants. They've also been seen going to schools and intimidating the principals due to how many, due to the amount of migrant students that they have. Judge Lester Adams on the 4th of November handed the judgment that Operation Dudula was to be stopped and that even migrants have these socioeconomic rights, just reinforced the case from 2020. Right now, the system needs to be a much faster, Chairperson. The law, I read in the Refugees Act 130 of 1998 actually explicitly states that refugees applications need to be reviewed within 180 days. But in reality, these often take longer than the 6 months due to severe backlogs, staff shortages. As such, Chairperson, this also violates two other laws that I have found, which is the Promotion of Administrative Justice Act and Section 33 of the Constitution. And Chairperson, everyone finds it frustrating when there are long lines, missing files, and bribery. Honorable members, I speak as part of the generation that will lead South Africa in the future. I believe that immigration should not be considered just a challenge, it should be considered an opportunity. Many migrants arrive with skills in healthcare, IT, construction, and agriculture. Some of these skills are skills that we as South Africa short and need. And I believe that the system should allow these people to work and contribute to our economy. While South Africa faces skills shortages and youth unemployment, I believe we cannot as well blame this to the foreigners, Chairperson. I believe that each department should be held accountable and provide jobs and provide frameworks and policies to help the South Africans as well as the foreigners. I believe that the bill should let migrants work legally while they wait for the applications to be approved. It helps them support themselves and their families, Chairperson. In conclusion, I ask that the committee ensure the bill carefully balances increased security with unwavering compassion and fairness. I believe that this is the key to a successful immigration amendment bill. Thank you.
Thank you, Stembiso. You just left 5 minutes, so I want to check if you have actually finished what you have presented to bring before us as the select committee, or you are
Yes,
fine? Okay.
I
No,
have finished, Chairperson.
okay, we want to thank you, and you must stay on the line so that you can listen to the responses with regards to your presentation. We have noted some important issues that will be clarified before in terms of what one have noted that where the emphasis from this particular process and this immigration bill. Stay on the line, and we want to appreciate your effort. I hope that the select committee will do something, because you are just 15 years and yet you have just take time to make sure that you make an input in this important process. We'll do the justice to you to acknowledge so that we can have a token of appreciation from us as the select committee for representing your age. Indeed, the future is young and the future is now. And we can see by your participation that the elders can hand over the baton now, because the new generation is coming by day in and day out. Stay on the line to continue following the session. Now we would call over the University of Cape Town Refugee Rights Units, Ms. S. Seda and Mr. Sky Kruger. I'm not sure how are you going to deal with this 10 minutes, but over to you with making your submission.
Good morning, Chair. Good morning, honorable members. Am I visible? I'm not sure.
Visible and audible.
Perfect, thank you. Can I share a presentation?
Yes, if you're not going to be delaying us, because you only have 10 minutes and there's two of you from the organization.
It will just be me presenting.
Okay, no, thank you.
Okay, is it presentation visible?
Yes, it is.
Okay. Honorable members, I am Shazia Seda. I'm a supervising attorney and head of our detention and deportation detention and deportation unit at the clinic. I want to start off by highlighting the vulnerabilities that are faced by asylum seekers and refugees in South Africa. In the case of Union of Refugee Women and others versus the director, refugees and apologies, I just want to move this way.
You must note you're eating on your time.
Yes, sorry, my connection. Is my presentation visible?
It is.
Okay. Apologies. Apologies. Refugees and those seeking asylum are unquestionably a vulnerable group in our society, and their plight calls for compassion. As pointed out by the applicants, the fact that persons such as the applicants are refugees is normally due to events over which they have no control. They have been forced to flee their homes as a result of persecution, human rights violations, and conflict. Very often, they or those close to them have been victims of violence on the basis of very personal attributes such as ethnicity or religion. Added to those experiences is the further trauma associated with displacement to a foreign country. Section 34(1) CIV, in terms of legal representation and interpreters, We recommend that the section places a duty on the South African Police Services, Immigration, the Department of Home Affairs, and magistrates to provide the details of legal aid or public interest lawyers. We further recommend that the use of a certified interpreter is mandatory if the detainee does not speak English. The reason for this is that deportation proceedings have very serious consequences for individuals, which include the risk of family separation or being returned to a place where they will face persecution. So detainees must have the right to understand the proceedings in a language that they understand in order to uphold the right to a fair hearing. In terms of Section 34(1) capital A, it applies to everyone, including children below the age of 18. We acknowledge that Section 28(1) G and 2 of the Constitution provides that every child has the right not to be detained, except as a measure of last resort. So we thus propose that Section 34(1) capital A be amended to read as follows. An immigration officer may arrest and detain an illegal foreigner over the age of 18 for purposes of deportation, provided that etc. We further recommend that Section 34(1) be amended to read as follows. Without the need for a warrant, an immigration officer may arrest an illegal foreigner over the age of 18 or cause him or her to be arrested. And then the section continues.
You're muted. Seda?
No, Chairperson, we can hear her. Maybe it's the network on your
Okay.
side.
I think it's on my side.
Am I audio? And am I still? Can everyone hear me?
Yes, ma'am.
Yes, now I can hear you.
Perfect. Thank you. In terms of the interest of justice, we encourage the inclusion in the prescribed factors of a consideration of an individual's intention to apply for asylum. So it's noted that there are currently no guidelines as to the factors that must be taken into consideration by immigration officials or courts when making an interest of justice determination. Such factors must be prescribed by the Minister of Home Affairs according to the amended Section 34(1) capital AAII. So thus we encourage the inclusion in the prescribed factors of a consideration of an individual's intention to apply for asylum. So because there are no guidelines that have been provided as to the reasonable conditions that may be imposed on a released detainee, and it is unclear whether this must be informed by the factors that are prescribed by the minister pursuant to the interest of justice determination. So we recommend that clarity be provided in terms of this. Section 34(1), refugees and asylum seekers, refugee asylum seekers and stateless persons cannot be returned to a place where they will face persecution, torture, or other serious harm. These individuals are protected in terms of Section 2 of the Refugees Act. We recommend that Section 34 be amended to include these vulnerable groups, such as refugee, asylum seekers, and stateless persons. And the section should be read with the additions that are in bold. I'll just read that out. Without the need for a warrant, an immigration officer may arrest an illegal foreigner or cause him or her to be arrested, provided that the officer ensures that the individuals that fall under the definition of a refugee, asylum seeker, and stateless person are released and referred where appropriate. The immigration officer shall, for those not listed in one of these categories, irrespective of whether such foreigner is arrested, deport him or her or cause him or her to be deported, and may, pending his or her deportation, detain him or her or cause him or her to be detained in a manner and at a place determined by the Director General, provided that the foreigner concerned, etc. South Africa has a long list of case law that supports that detention is not required. In the case of Ulde versus the Minister of Home Affairs, which was an SCA case, the court stated that the immigration officer must still construe the exercise of his discretion in favor of liberty when deciding whether or not to arrest or detain a person under Section 34(1) and be guided by certain minimum standards in making the decision. In the case of Jiba and others versus the Minister of Home Affairs and another, which was in 2009, the SCA again confirmed that an officer who decides that an illegal foreigner is liable to be deported has a discretion whether or not to arrest and detain the person pending his or her deportation. So there is no obligation to do so. And again, in Lawyers for Human Rights versus the Minister in 2003, it was stated that the discretion that an immigration officer has not to arrest a person as limited, having regard to the fact that Section 34(1) applies only to foreigners who are by definition in the country illegally. We further recommend that Section 34 should include alternatives to immigration detention. And these are some of the alternatives to detention that we suggest. So report to a police station or an immigration officer regularly to maintain contact. There can also be case management, so regular check-ins by immigration officials, provision of a notice pending deportation, voluntary repatriation without the need for detention, and residential alternatives such as halfway houses for refugees, asylum seekers, and stateless persons. And this is to uphold the right to liberty and freedom from arbitrary detention. I just want to note, we wish to note the consequences of deportation and the severity thereto. And some of the consequences is that after an asylum seeker is deported, it's very severe in that they will have left South Africa, the damage will have been done, their lives, homes, and jobs in South Africa will have been lost beyond repair. They may be harmed or killed if they are deported to an unsafe country. For example, if they are made to return to either the east of the DRC or to Palestine, etc. We urge the Minister to reconsider the bill as a whole, particularly in light of the vulnerable groups that are in our society, which are occupied by asylum seekers, refugees, and stateless persons, because of the state's obligation to provide such persons with administratively fair processes, as well as protections where applicable. I'd like to end off by reminding the honorable members of the SCA case of Wachanuka, where it was stated that human dignity has no nationality. It is inherent in all people, citizens and non-citizens alike, simply because they are human. And while that person happens to be in the country for whatever reason, must be respected and protected in terms of Section 10 of the Bill of Rights. Thank you very much. That's everything from my side. I will just stop sharing.
Thank you, Ms. Seda, and you are within your time frame because you were supposed to at least end at 10:40. You just left 3 minutes. So there's nothing that you would want to say that you would want the committee to note.
Nothing further from my side. Thank you very much.
Okay. No, we thank you for your submission. You can just stay on the line and follow through the discussions. Now thank you, ma'am. We'd like to hand over to Lawyers for Human Rights, Ms. Nyeleti Baloyi. Over to you, ma'am.
Good morning, Chairperson. Good morning, honorable members. I would like to share a presentation as well, if I can find it. Okay, it's fine. I can't seem to find it on here. I'll just proceed with my presentation without the PowerPoint presentation. Honorable Chairperson and esteemed members of the Select Committee on Security and Justice, thank you so much for the opportunity to address you today. My name is Nyeleti Baloyi, and I represent Lawyers for Human Rights. We are here to present our submission on the Immigration Amendment Bill B8B of 2024. Honorable Chairperson, Lawyers for Human Rights welcomes this bill. We support its intent, which is to remedy the significant constitutional defects in the Immigration Act, as mandated by the Constitutional Court in the landmark case of Lawyers for Human Rights versus the Minister of Home Affairs judgments. However, while we support this intent, we must admit that the bill, in its current form, has fundamental shortcomings. It fails to meet the clear constitutional standards of procedural fairness, dignity, and access to justice that the court demanded. The bill introduces conditional rights and retains institutional loopholes that ultimately leave it and the sections it seeks to amend constitutionally vulnerable. The central flaw of this bill is that it adheres to the letter of the court's ruling, but completely fails to implement its spirit. The Constitutional Court didn't just ask for a 48-hour court appearance. It mandated genuine substantive judicial oversight to protect the right to liberty. The bill creates loopholes that risk turning this new court process into a mere rubber stamping of detention. This repeats the very unconstitutionality it was meant to cure. A right to judicial review is meaningless if it is not genuine, fair, and an informed process. Our first major concern relates to the very language of the bill, which has profound implication for human dignity. The bill continues to use the term illegal foreigner. Honorable members, no person is illegal. This terminology is legally imprecise, offensive, and dehumanizing. In the South African context, it is a painful echo of our apartheid-era past laws. This language is not neutral. It feeds harmful xenophobic narratives and is the indirect violation of the founding constitutional values of human dignity found in Section 10 of the Constitution and Section 9, which provides for equality. We strongly recommend that this term be expunged from our legislation and replaced with the accurate neutral terms irregular migrant or undocumented migrant. The second language issue, even more critical, is related to the legal process. The bill grants detainees their rights to interpretation, including during the 48-hour review, but only when it is possible, practical, and available. That is a direct quote. This clause, honorable members, is an unacceptable loophole. A right that is conditional on state convenience is not a right at all. What does this mean in practice? It means a detained person who does not speak English can be brought before a magistrate, be unable to understand the proceedings, and be sent back to detention and ultimately be deported. Without a guaranteed interpreter, the constitutional right to challenge one's detention is, in the words of our submission, illusory. We recommend this right to be unconditional. Our second focus is on the vague legal standards the bill creates. The bill introduces two critical legal tests, the interest of justice test and the release on reasonable conditions. What is baffling is that the bill fails to define either of them. It delegates the definition of interest of justice to future ministerial regulation. This is a delegation of a core constitutional safeguard. It leaves police officers and magistrates, as well as immigration officials, with no objective benchmark, which invites arbitrary and inconsistent decisions. This is a clear violation of the rule of law, which demands legal certainty. We recommend that these terms be clearly defined within the Act itself, using the established and proven principles from the Criminal Procedure Act, and the exact wording that we suggest can be found below paragraph 38 of our written submissions. This brings us to the right to legal representation, an empty right. This is what a 48-hour appearance is for an indigent person who speaks a foreign language and has no lawyer. The bill is dangerously vague on the right to legal aid. This is not just a procedural gap, it is a fatal flaw. The right to challenge one's detention, as found in Section 35 of the Constitution, and the right to fair administrative action, as was also eloquently elaborated by the young person's Tembiso, are both impossible to exercise without legal counsel. The bill must be amended to explicitly guarantee the right to state-funded legal representation for these 48-hour review hearings. Finally, Honorable Chairperson, we must address the use of detention itself. The fundamental principle is that detention must be a measure of last resort, not the default. This requirement is promoted by the core spirit of the South African Constitution and by the broader international human rights framework. While the African Charter on Human and People's Rights strongly protects the right to liberty in its Article 6, the principle of detention as a last resort is derived from the confluence of this protection and other international norms. South Africa's current system is indistinguishable from a punitive criminal one. It is costly, harmful to vulnerable people, and in many cases, completely unnecessary, as also well eloquently elaborated by my colleague, Ms. Shazia. The bill was the perfect opportunity to legislate for a more humane, cost-effective, and constitutional approach, yet it completely fails to mandate or even promote the use of alternatives to detention. For example, instead of a 300 Rand a day prison cell at Lindela or in a correctional facility, we could use community-based reporting, which would allow individuals to live in the community and simply report to Home Affairs, or open accommodation centers that are not prisons, which allow case management and access to services. These systems are more humane, more just, and more cost-effective. In conclusion, honorable members, the bill before you is a temporary fix that fails to cure the constitutional disease. The loopholes on interpretation, the failure to define legal standards, the vagueness on legal aid, and the omission of alternatives to detention mean this bill is constitutionally vulnerable. It will be challenged in court, and it will likely be struck down again. This committee has a crucial opportunity to stop the cycle. You have the power to pass a bill that is durable, that is constitutional, and that is just. To that end, Lawyers for Human Rights submits 5 key urgent recommendations. Replace the term illegal foreigner with undocumented migrant. Guarantee unconditional access to language interpretation. Guarantee state-funded legal representation for 48-hour review. Define interest of justice and reasonable conditions within the bill. And finally, codify a framework for alternatives to detention as the default option. Honorable Chairperson, members of the committee, we thank you for your time and attention. That brings me to the conclusion of my presentation. Thank you.
Thank you, Ms. Nyeleti, for your input and as well your presentation. And what is interesting about all your submissions is that you have recommendations in terms of what you would want us to note as issues of that are constitutional right to be included in such legal documents. And I hope that you will stand on the line to follow through the conversation and get the responses as well from the department and our legal advisor. You are within your time frame, you did well. It really shows that you really understand the process of Parliament, that we are working within timeframes. We would now call through Scalabrini Center of Cape Town, Mr. James Chapman. Over to you, sir. It's 10:47. You can use the 3 minutes left by Ms. Nyeleti, but don't overlap to your 10 minutes. Over to you.
Thank you very much, and greetings. I stand by the protocol. Greetings to you all, honorable members. If I may, I'm just going to share my presentation. Is it visible?
It is visible.
Thank you very much. All right. The Scalabrini Center is an organization that has a mission to welcome, protect, promote, and integrate people on the move, including asylum seekers, refugees, and other vulnerable migrants within local communities. And we would also like to commend and appreciate the bill, which has a lot that is really good going for it. Prior to the amendments suggested by the court and then proposed in the bill, if you were arrested for criminal reasons, you would be brought before court within 48 hours. But for a civil matter, which is what is being dealt with here, you wouldn't within 48 hours. So at least now there is that judicial oversight that one appears before a court There is a assessment in terms of interest of justice. There's reasonable conditions. These are really positive. There is a need to define what constitutes interest of justice. Also, we really appreciate that there is cognizance of representations that were made and that an amendment between the previous iteration of the bill and the iteration before the National Council of Provinces in terms of making a certain degree of provision for state-funded legal aid. And so that is a slight improvement. However, there is still a greater need for further protections, further provision in terms of legal aid provision for children, for asylum seekers, stateless persons, trafficking survivors of human trafficking. I will try to be a little bit faster with respect to matters that have already been covered by my colleagues in the interest of time. It is completely clear and important to acknowledge that every state has an interest in deporting and setting out process for deportation, but deportation does not necessitate detention for deportation. One wants to look at, from the perspective of the state and also from the perspective of the individual, what is the most efficient, cost-effective, and humane mechanism to process in terms of deportation. Also, there needs to be cognizant of who cannot be deported. I mean, you may deport somebody where it's safe to do so, but you cannot deport somebody to face torture, contrary to the Convention Against Torture. You cannot deport somebody to face persecution, violence, war-torn situation, or death in terms of the Refugees Act. You can't deport somebody who is a survivor of human trafficking. And in essence, then you perpetuate the trafficking and let the trafficker continue with their so doing by removing the vital witness in such a case. Never mind the completely inhumane nature of detaining and deporting a survivor of trafficking. There needs to be these safeguards in place. As I say, deportation does not require detention. There are really reasonable and positive alternatives that would save the country an enormous amount of money, are more humane, and much more feasible and practical than the current system. And then, so we're going to look at how the bill may be improved upon. So in terms of the bill currently, it doesn't speak specifically to these vulnerable populations. Section 34 enables immigration officers to arrest and identify. And I concur with my colleague. One should never be using. Nobody is an illegal. It's a complete derogation of dignity. It should be an irregular.
Mr. Chapman, you are freezed. I'm not sure if it's on my side. Members, can you still hear him?
No, he appears to be frozen.
Okay, Mr. Chapman? Mr. Chapman?
Should be network problems, Chair.
Yeah, so police, can you give me some few minutes so that some of our support staff can check on him?
Absolutely.
Okay, thank you. Oh, I can see that now he has left the platform. I would want the support staff to just check on him. Mr. Chapman?
Terribly sorry. I had
Yes,
a connection.
okay, you can then switch off your video because I think it's the one that is causing these glitches. Then you can
Right.
continue where you left, where you were emphasizing on the wording of illegal.
Thank
No,
you.
no,
Thank
no.
you. Chairperson, are you able to
We can see the presentation. You are just here. Yeah.
Okay, perfect. Okay, so as I was saying, the current framework should provide, but doesn't currently provide for those who fall within the refugee definition, stateless persons, survivors of human trafficking, who should not be arrested but referred where appropriate. And that's our clear recommendation. I also concur with my colleague Naleti in terms of it should be irregular migrant, not illegal foreigner. There is provision, and as I said in the beginning of my presentation, there is a laudable improvement with the bill that it now says that you can have state funded legal practitioner where substantial injustice would result. The problem is that that's a far cry less than what happens within criminal matters. And it means that the fundamental dignity of people who may gravely need legal representation would be omitted by this iteration. For example, if somebody is illiterate, somebody who doesn't have means, somebody who would be, if they are deported, they would be returned to face persecution, war, violence, a perpetuation of trafficking, torture. Such a person may be denied legal aid with the current iteration. And so we suggest that rather the bill is in line with um, the legal aid manual when it talks to criminal matters, legal aid in other situations where it talks to people should be entitled to, those who cannot afford legal representation should be entitled to state funded or legal aid at state expense. That would ensure that the fundamental dignity, the protection of an individual from persecution, war, violence, or death is protected and guarded against. Also, my colleague already spoke to the Ilde case, Ms. Sada from UCT, and so I won't speak to it further, save to say that the bill should also be amended in terms of Section 34A1 to say that discretion should be exercised in favor of freedom, in favor of liberty. So, also, I'm not going to labor it further, save to say that there's still a huge problem on omission of those under the age of 18. I don't think it was ever the intention of the legislature to include people under the age of 18 facing detention for the purpose of deportation. And in fact, there is a moratorium in place from detention for deportation, and the department, in engaging on this amendment in the past, has talked to how the default position is to refer somebody to the Department of Social Development, to designated child protection organizations. So the legislation needs to be crisp and clear to talk to only those over the age of 18. Then there needs to be protection against people being returned to persecution, violence, or war. That's set out in Section 2 of the Refugees Act. And so in accordance with that, anybody who falls within the definition should be excluded from the application of Section 34, lest they be returned to persecution, violence, or death. We also make a recommendation that there needs to be a proper consideration of alternatives to detention. Now, this has been spoken about by the two former speakers, but I think it really needs to resonate and be heard, because it is about the fundamental dignity of a person. If somebody's dignity is not protected by spending months and months in a prison holding cell, often in police holding cells that are not designed for holding people for more than 48 hours. But beyond the human rights side, which cannot be stressed enough, there's also the cost implications and the practicality. It's much easier, better, simpler for the state to apply alternative detention and not to detain. And in fact, it's a practice that South Africa used to employ time and time again in 2008, 2009, 2010, 2012, 2015, time and time again. they would advise somebody that they were to be deported, they would get a particular date, and they would await the date not in custody. But in recent years, there has been a shift away from that at enormous cost to the state. I think I lastly would really just like to hone in alternatives to detention. You look at places where alternative detention are adopted, and you see an 86% adherence to immigration procedures, only 12% absconding. And if there's absconsion, then those individuals may be dealt with, but the 86% can be dealt with without that. There's an improvement in psychosocial well-being and psychological well-being. There's an increase in participation, 99 increase in participation. In a 2022 evaluation, in terms of government-sponsored alternative detention in the United Kingdom, for example, you saw more stability, more health and well-being, and I repeat, no decrease in compliance with immigration systems. You see the same in South America. You see the same in Portugal. You see the same in multiple jurisdictions, including a lot of developing countries where these alternatives are applied and employed. So in conclusion, we need to aim for a more humane, dignified deportation process that includes proper judicial oversight, provision for interpretation services, for legal representation to everybody who cannot afford it, consideration and prioritization of alternatives to detention, because alternatives to detention will reduce the cost to the state, will be less cumbersome and more efficient, easier to apply, and most importantly, respect fundamental human rights of individuals. We're not talking about individuals who may have been trying to cheat the system and are in the country trying to abscond, because whether there's detention or not, such individuals continue like that. We're talking about a refugee who has somehow been rejected, who has administrative rights to address that so they're not returned to torture, persecution, violence, or war. We're talking about a survivor of human trafficking who should be an asset to the state to challenge through the courts the actions of a trafficker. But instead, if they are arrested, detained, and deported, the trafficker wins, and the South African state, the individual, everybody else loses. Detention may be applied, but it should at absolute be a last resort, and decision making should be in favor of liberty. Thank you very much. These are my submissions. I appreciate the opportunity.
Thank you, Mr. Chapman, for a detailed presentation. And one is noting that there are commonalities in terms of the inputs and as well suggestions from all parties that have been with us today. We have noted that Enoch Mbau, you are speaking from everyday experience, concerned about implementation of the bill, strain of the judicial system in respect of 48 hours requirements in the bill, broader socio-economic burden raised in technology focus group, which recommends modernization of immigration and enforcement. And I know some of the members here on the platform, it's one of their core focus to say we would need to modernize most of our system to ensure that we have efficient and effective systems. Sitembiso Lamont, our young learner, spoke on immigration that reflects who we are as a country by balancing different interests. We should be guided by the Constitution in deliberating on this bill and emphasizing that non-citizens have socio-economic rights like health, care, education, and social services. Migrants have skills that South Africa needs, so we need to strike a balance. From UCT, I have noted that refugees are a vulnerable group in our society, emphasizing the need for legal aid and interpreters, and as well concerned about the rights and protection of children. Emphasizing on vulnerable groups should be included in Section 34 of the bill, and also raise alternatives to detention. And as well, the LHR welcomes and supports the intent of the bill, concerned about procedural fairness, terminology to be revisited, and as well the interest to justice and reasonable condition need to be defined, emphasis on the right to legal aid and suggest on alternatives to detention. For our last speaker now, Mr. Chapman, we have noted that there is a need of more strengthening regarding children asylum seekers and stateless persons and trafficking survivors, and need to define interest of justice, more provisions of legal aid, proposing as well alternatives of detention. We have noted the following, and we would now receive presentation from the Department of Home Affairs, and just immediately after the Department of Home Affairs, will then hand over to the Office of the State Law Advisor in Parliament Legal Services to comment as well before members.
Recording
engage.
stopped.
Over to you, Advocate Malakate.
Good morning, Chair. I hope you can hear me loud and clear. My name is Tommy Makode. I'm DG at the Department of
Yes,
Home
we can hear you.
Right, so I'll just ground the video. Just in short, while Advocate Malakate is joining because he's doing another presentation on the other side, really, from our side, we really want to appreciate all the inputs that have been received, and would like to indicate that we have received and we have considered all the inputs. And then to indicate that the provisions, Chair, of the Immigration Amendment Act, as advertised by yourselves as a select committee, those written inputs have been submitted. We've analyzed the written inputs, including those by the content advisor, and wish to indicate as well that in particular, we are responding to issues that have been raised in the judgment. The presentation will seek to address the Concord judgments as advertised, colleagues, by the Select Committee, and the written comments received. Chair, you have just raised this issue. They straddle between policy and technical amendments that are relating to the direct content of the bill, and some submissions that were received, and I've been listening attentively. Chair, they go beyond the ambit of the current amendment to the bill and focus on other broader concerns and are in general in nature, referring to the immigration system at large. You will be familiar, Chair, with the fact that we're currently amending, or we're in the process of working on a white paper on citizenship, immigration, and refugee protection. And some of those issues are dealt with there, including a comment around modernization, the comments that were made by Enoch Mbau at the beginning. So without any waste of time, Chair, I'll then hand over to Advocate Malakate to take you through the presentation. Thank you.
Thank you, Mr. Makobe. Over to you, Advocate Malakate.
Good morning, Chair. I hope you are able to see me. I have opened the camera. Chair,
we see two gentlemen behind, so I'm not sure if you would want to switch off your video and continue without the video, or you are fine with your connectivity.
No, thank you, Chair, for that. Chair, as DG has indicated, I'm sitting in one of the waiting rooms here in the parliamentary precinct, waiting to get into another meeting. But Chair, and I'm not going to go through point by point on both the oral submissions that have been made today, but also on the written submissions that have been received by the Select Committee, as well as those that have been submitted. But Chair, on a protocol issue, let me greet you, Chair, as well as the members of the Select Committee, and also amplify what the Director General has indicated in terms of thanking those who have submitted the written comments, but also those who have also made oral submissions today. Chair, the issue relating to moving away from using the term illegal foreigner and replace that word and insert the word or prefer the words that have been suggested today, ranging from irregular migration and so on. This for us requires a broader discussion, and as DG has indicated, this should be and can be dealt with when we deal with the immigration, with the white paper on immigration, citizenship, and refugee protection. And of course, we will need to take this into consideration as we do that work. Simply because, Chair, if we were to change the terminology from illegal foreigner to irregular migration, that will also have an impact on other pieces of legislation within the entire South African legislative ecosystem. So, and we had not yet at this particular point in time did an audit on what would be the impact both on the Immigration Act, but also as well as on the Refugees Act that are administered by the Department of Home Affairs, but on other organs of state that may be impacted by that change. But we will take that into consideration as we deal with the white paper on citizenship, immigration, and refugee protection. Chair, when we come back to the issue that is being raised from both the oral and written submission relating to the term interest of justice criterion, Chair, if we were to zoom and look into the two Constitutional Court judgments themselves, the Constitutional Court does speak to what is in the interest of justice criterion and what are the factors that may be taken into, but there is no clear definition within the South African jurisprudence in terms of what is meant by what can be these factors. These are sometimes even circumstantial. They look at the circumstances of an individual. But if you were to look as those who have made oral submissions today have indicated, if we were to look at the criminal procedure, there are issues, there are factors that would need to be taken into account. For instance, whether or not the individual has a verifiable physical address, whether or not such an individual is a flight risk, and so on. You will recall that in terms of that process, the intention is to bring the person before the court so that the full extent of the law is then taken care of and the procedures are then followed. So when we were dealing with this, the first iteration of the bill did not have or did not empower the Minister of Home Affairs to tabulate the factors that the immigration officer would need to take into consideration to determine whether or not the interest of justice allow for the release of such an individual, or whether or not the immigration officer should proceed to detain an individual. We then, at the Portfolio Committee, inserted or empowered the Minister of Home Affairs to then determine these factors, because they were not in the initial iteration of the bill. The minister did not have this power.
Advocate Malakate, I thought it was only me who's seeing a stagnant presentation. We are still on page 3 in terms of the slides that is flighted. So I'm not sure on your side if you didn't do the slide modes so that we move with you as you present.
Oh, Chair, I had then I was guided by your guidance at first to say that when you said that the presentation has been received and that perhaps we can deal with the issues. So I'm not going on a slide by slide, but dealing with the issues that have been raised both from the oral and written submissions. But I can go slide by slide, Chair. I will be guided by yourself.
Okay, just go directly now to where you've been in terms of factors to be considered, so that at least you can move from there up until to your last part of the presentation. and taking in consideration that time that it's left on your side as well.
Thank you, Chair. So I am speaking on slides number 11, 12, 13 and 14, which deals with the interest of justice criterion, and both from the and we can go to slide number 15, just to indicate that within the South African jurisprudence, we would be following what has been reiterated or indicated by our courts in terms of what factors the minister should need to look into in developing the regulations to determine the factors that an immigration officer would need to take into consideration. So in slide number 15, we're just placing before the select committee some of the judgments that have dealt with the interest of justice. And I was just indicating that in the factors, when we do look at that, we would be in developing the regulations. This is in slide number 16, that we are going to look into some of the factors that are coming out from the criminal justice to see whether or not they would fit the purpose within the immigration space in terms of how we deal with illegal migration and those persons who have been arrested for purposes of deportation. And as I was indicating, Chair, that some of the factors that one could look into without, of course, prescribing or indicating that this would be what the minister would need to look into, but just that at some within the criminal justice system, we look at also at issues whether the individual has a verifiable physical address, as well as the issues related to whether or not the individual is a flight risk and so on. But those are the factors that, as the minister, as we develops the regulation, the minister would then need to look into. The second issue that we're going to deal with under slide numbers, from slide number 17 right up to slide number 19, it's issues related to what we have termed Section 35(2) rights, but in particular, issues relating to interpretation and communication. Both my learned colleague from the lawyers from Human Rights and Mr. Chapman, and my learned colleague also from the University of Cape Town have aptly dealt with this issue, that those who have been arrested for purposes of deportation must fully enjoy the rights that are contained in Section 35(2), which includes the right to legal representation, but also to be communicated with in the language that they may understand. So, Chair, in slide number 19, we just want the select committee to be reminded that in terms of Section 35(4) of the Constitution, the Constitution already clearly indicate that whenever the section it's required, which this bill seeks also to give effect to, given the two Constitutional Court judgments, is that the information must be provided in a language that the person understands. And this bill also takes into consideration that, however, there would be other operational issues that we would need to deal with in terms of satisfying that the requirement as stipulated under 35(4) of the Constitution is to be met. But the department also has interpretation services within which we provide interpretation where there is a need to provide. So, but we also need to place before the select committee that there was submissions relating to issues on where we are using the words where applicable or as and when required to do so. And we just wanted to place before the select committee that Section 34(1)(c) of the Principal Act was never before the High Court, nor was it before the Constitutional Court, both in 2017 and 2023. And therefore, the both courts did not pronounce themselves on Section 34(1)(c), and therefore, in our view, that provision remains to be valid, and has not been declared inconsistent with the Constitution. So, in the next part, when we come to issues relating to legal representation, we wish to submit, Chair, that falls within the mandate of the Legal Aid Board of South Africa, and the operationally we may just need as a department just to have a conversation and discussion on how best we can deal with it. But over and above on other issues that both the written and oral submissions have raised, relating to ensuring and clearly tabulating in the provision that there has to be that right. Those are issues that we believe can be taken care of, and when we deal with the white paper on immigration and citizenship and refugee protection further. But the mandate as it relates to providing legal aid is vested with the Legal Aid Board of South Africa, and also within the Department of Justice and Constitutional Development. In the next slide, in slide number 20 to slide number 22, Chair, this is dealing at a thematic level with the protection of vulnerable groups, and you would have heard both from Mr. Chapman, as well as Member Lowy, as well as Ms. Adair and the others, that the issue is about the protection of vulnerable groups. Inter alia, they mention asylum seekers, refugees, and stateless persons. We wish to submit, Chair, that the Refugees Act deals aptly with the issues that have been raised as it relates to asylum seekers and refugees. And in fact, Chair, where a person has been arrested and raises, for lack of a proper description, raises his hand and indicates that he or she wishes to apply for asylum, the department provides and is mandated to ensure that the person is afforded an ability to do so. Chair, there is in 2021 there is a constitutional, there's a judgment in Abore versus Minister of Home Affairs, where it was clearly indicated that there are certain circumstances that the department will need to look into as it deals with that intention, or that raising of an intention to apply for asylum. But what we can submit clearly that the department does provide an opportunity for those who wishes to apply for asylum and provide them with an opportunity to apply for asylum, and that the department, through our refugee reception centers, as well as our Standing Committee on Refugees Affairs, as well as the Refugee Appeals Authority, that we deal with issues related to applications for asylum in full. But of course, we need to also look at what the Constitutional Court has indicated as it comes out from the judgment in Abor. But when it comes to issues related to statelessness, Chair, we submit that South Africa, if we were to look into the South African Citizenship Act, deals with issues related to statelessness and provide a mechanism where South Africa can grant citizenship if a person meets the circumstances or meet the requirements that have been tabulated in those provisions. But the issues related to statelessness we also submit that we are able to deal with them, and we can have a different approach as it comes to those who are stateless. Similarly, Chair, when it comes to those or to children, the department operationally, as well as through our standard operating procedures, we are able to rechannel those who have been found to be in need of care and protection, as it is stipulated in the Children's Act, that we rechannel them through the Department of Social Development, and for the Department of Social Development to then carry over the issues related to that. Chair, as I conclude, the issues related to alternatives to detention, Chair, we submit that those are issues that are broader, and that goes beyond the intention or the scope of this bill, and that such can properly be dealt with under the white paper on citizenship, migration, and refugee protection. With that, Chair, we submit, and I thank you for the opportunity.
Thank you, Mr. Malagate, for actually executing your dual responsibilities today with the committee that you are with and us as the select committee. Now we are handing over to our legal advisor from Parliament.
Good morning, Chairperson, honourable members, stakeholders and colleagues. I'm Daksha Kassan. I'm from Parliamentary Legal Services. And on this platform with me, I also have my colleague, Ms. Claria Williams, who will be flighting the presentation and also assist in fielding any questions that may arise following the presentation. Chair, I just want to start off by saying that our office too has considered the written submissions that were received by the Select Committee, and we also then analysed the written submissions as prepared by the Content Advisor. We, however, would like to then comment only on the legal and constitutional concerns that were raised in these submissions. Policy issues such as alternative to detention, legal aid, legal representation, and so forth, as well as the resource and implementation issues were left for the department to address. Moving on to the next slide. Chair, I just want to very quickly recap on the main findings of the Constitutional Court in the two judgments that the bill seeks to address. In these two judgments, the court held that Section 34(1)(b) and D of the Immigration Act were inconsistent with Section 12(1), which is the freedom and security rights in the Constitution, as well as the Section 35(2)(d) rights in the Constitution, which is the right to challenge the lawfulness of the detention in person in court. The main findings, therefore, of this court was that Section 34(1)(b) was unconstitutional since it did not require an automatic judicial review of a detention before 30 calendar days had expired. That Section 34(1)(d) was unconstitutional because it did not require the appearance of the detainee in person in court before any decision to extend the detention for a further 90 days was taken, and that the section was unconstitutional because it conferred very wide powers to detain without any objectively determinable conditions or guidance for the immigration officer on how to exercise that power. So having said that, this bill that is before this committee seeks to particularly address the findings of these Constitutional Court judgments. Now, as the department mentioned, the comments received through the written submissions straddle both policy and law relating to the direct content of the bill. However, some comments received go way broader than the bill and also deal with other pieces of legislation and with the immigration system at large. Our presentation, however, will only focus on the legal and constitutional issues raised in respect of the content of the bill that is before this committee. And very importantly, Chairperson, this presentation will also very briefly refer to the Portfolio Committee on Home Affairs deliberations and some of the decisions taken there on the issues raised, merely to serve as background information to this committee on the process that the bill underwent in that committee. Moving forward then, the first issue I would also like to touch upon is the interest of justice criteria, which is stipulated in section 1A, small section A, Roman numeral 2 of the current bill, which provides that an immigration officer must consider whether the interest of justice, which was a standard that was introduced in the court order in the two judgments I alluded to. And what it provides is that the immigration officer must consider the standard after taking into account relevant factors that must be prescribed by the minister, and only after he's taken into account those factors must he take a decision as to whether the interest of justice standard permits the release of such foreigner. Now, we've heard this morning as well, and what came through in the written submissions is that submitters are saying that the bill must include a definition for this term, interest of justice. We've also heard submitters present that the factors that must be taken into account must be contained in the bill itself. In other words, in the primary legislation and not in the regulations as the bill currently provides for. We've heard by submitters saying that failure to codify these factors would leave immigration officers with broad, unchecked discretions. And submitters are also saying that these regulations must come into effect when the bill comes into effect so that the bill can be implemented. We've also heard that the term reasonable conditions must be spelled out in the regulations. Now, in response to this, Chairperson, I'd just like to quickly say what this interest of justice standard is. In terms of jurisprudence, it's described as a useful term denoting, in broad and evocative language, a value judgment of what would be fair and just. It involves an overall evaluation of all interests involved. It is a legal standard that evaluates whether actions taken in a case serve the fair administration of justice. Now, as the department mentioned, the term is found in the Constitution in those sections that are listed there. And we can move on to the next slide, please, Laura. The term is also found in a range of South African legislation, ranging from the Criminal Procedure Act, the Child Justice Act, the Domestic Violence Act, and so forth. What I'd like to stress is that in these pieces of legislation, the term itself is not defined, but what rather happens is that the factors that must be taken into account when considering the standard are listed either in the primary legislation itself or in regulations. And there I've referred the committee to two particular examples where the interest of justice standard is mentioned, but what immediately follows after it's mentioned is the factors that must be taken into account in determining what would constitute the interest of justice. I also want to refer this committee to comments made in the Constitutional Court judgments that's under discussion. What the court said there is that while the interest of justice criterion is well known in our law, the courts have confirmed that because of its breadth and adaptability, it is prone to imprecise understanding and inapposite use, and it can create the risk of uneven application. And then in the 2023 judgment, the court specifically acknowledged that not every decision maker under Section 34(1) of the Immigration Act will be a judicial officer. And for an immigration officer, an interest of justice test may well present interpretive challenges. Now, having said that, in light of these comments that the Constitutional Court made, recommendations were then made to the Portfolio Committee on Home Affairs that factors needed to be provided for an immigration official to consider when considering whether an interest of justice permit the release of a person. We had advised the committee at the time that such factors could either be in the bill itself, meaning in the primary legislation, or that the bill provide that the minister must set out these factors in regulations so that an immigration officer is provided with guidance on how to exercise his or her discretion. And this authority, Chairperson, we got in the well-known Dawood versus Minister of Home Affairs judgment, where the court specifically said that when there is an unfettered discretion that must be exercised by an official, guidance for that discretion or the exercise of that discretion could be provided either in the legislation itself or, where appropriate, by a legislative requirement that delegated legislation be properly enacted by a competent authority. So we submit, Chairperson, that the way that the clause is currently presented in the bill, which says that those factors must be prescribed in the regulations, is actually in line with constitutional jurisprudence. There was also this issue about the fact that reasonable conditions has not been made clear. In this respect, we want to refer the committee to Section 7(1), paragraph P of the Immigration Act, which empowers the minister to make regulations for the better achievement of the objects and purposes of the Act. So that particular provision will entitle the minister to include providing guidance on what reasonable conditions should entail in its regulations. Moving on, Chairperson, the next issue I'd like to touch on is the issue of children. The department has spoken about the other categories of vulnerable groups that have come up during the submissions. Now, during the submissions, what came out is that the bill does not provide any safeguards for children in line with Section 28 of the Constitution. The submissions were that Section 34(1)(a) could be interpreted to apply to all persons, including children, and therefore this section can then be interpreted that even children can be arrested and detained. And another submission was that any case then involving children should be referred to the Department of Social Development or the relevant child protection organization. Now, in response to this, Chairperson, we'd like to stress that Section 28 of the Constitution provides special protections for every child in the Republic, not just a South African child, but every child that is found within the borders of the Republic. The section also defines a child as a person under the age of 18 years, and there are various other rights included in Section 28, which are contained in this bullet, which I, for the sake of time, will not repeat here, except to say that I'd like to stress that one of the rights is that for a child, the child should not be detained except as a measure of last resort, and then only for the shortest appropriate period of time, and when detained, the child must be kept separately from detained adults. Now, in the Immigration Act, it is noted that the term child is not currently defined. The current Immigration Act also uses the word minor in various sections. In one section, the child is referred to as a child under the age of 21. The current Immigration Act does not expressly state how unaccompanied migrant children should be managed and dealt with, and it does not expressly provide that detention of children be a measure of last resort and that children be detained separately and for the shortest appropriate time. If I can have the next slide, please. Now, during the deliberations in the Portfolio Committee, Chairperson, we did make recommendations to the Portfolio Committee to bring the bill in order to align with the Constitution, to make it clear that the child will not be detained under Section 34. We also recommended to the committee that the bill, similarly to the Refugees Act, explicitly provide for how unaccompanied migrant children should be managed and treated. And in blue font over there, we give an example of how the clause is crafted in the Refugees Act. Next slide, please. We also recommended to the committee that the current bill, similarly to the Refugees Act, provide that detention of a child must be used as a measure of last resort and that children be detained for the shortest appropriate time. And in blue font again, we've got the wording that appears in the Refugees Act as an example. However, Chairperson, during the deliberations, the department had informed the portfolio committee that as per their practices, and as we've also heard this morning, there are various SOPs that the department has regulating children. They had informed the committee, as well as I think here this morning, that children are not detained, and that when an unaccompanied child is encountered, the child is taken to the Department of Social Development immediately. And after these deliberations, Chairperson, the PC was satisfied by the department's response that special arrangements are actually currently in place for children, and that they are not arrested but taken to the Department of Social Development. The portfolio committee was also of the opinion that in this bill, it was best to only deal with the immediate findings of the Constitutional Court judgments that I alluded to, and took the decision that the issue of children would best be dealt with comprehensively in the department's white paper process that is currently undergoing. And in that review, the issue of children be expressly provided for, and that provision is made for their express protection. Moving on, Chairperson, the department also raised this issue earlier. We're currently in section 34(1)(c) of the bill. The bill provides that a foreigner who has been arrested and detained must be informed of his or her rights in a language that he or she understands when possible, practicable, and available. Now, submissions were received to say that these words, when possible, practical, and available, serves as a limitation on the right and violates section 34 of the Constitution, and that these words rather be replaced with the words must be ensured through interpretation services where necessary. Next slide, please. Chair, section 35(4) of the Constitution, as the department also referred to, provides that when that section requires information to be given, that information must be given in a language that the person understands. Now, the section in the Constitution is not watered down or subject to the caveat when possible, practicable, and available as it is in the bill. However, at this point, I want to remind once again, just want to refer to section 36 of the Constitution, Chair, which allows for that particular right to be limited if such limitation is considered to be a reasonable and justifiable limitation. Section 35(4) also does not say that the person must be informed in his or her mother tongue. It states that the information must be given in the language that the person understands. And so during the portfolio committee deliberations, the department had informed the committee about its various challenges that it would face if those words would be deleted, that there will be huge financial implications. We've also heard the department allude to some of the challenges that might be encountered, and in sourcing interpreters that speak the language of the foreigner and that do not speak an official language. The portfolio committee then, after hearing these challenges, were of the view that those words should remain as they serve as a reasonable and justifiable limitation. Then the next slide, please. Chair, we also heard this morning that a submission was made that the word substantial injustice is unfair towards certain foreigners that would be seeking legal representation. And the submission was that it would be an injustice to limit legal representation to those meeting the substantial injustice threshold. In response to this, Chairperson, I'd just like to say that the right to state-appointed legal practitioners at state expense, if substantial injustice would otherwise result, is actually a constitutional threshold and is currently stipulated in section 35(2)(c) of the Constitution. And then On my last slide, Chair, I'd just like to address some of the drafting issues that were mentioned in the written submission. One of the submissions was that the bill needs to clarify that courts referred to are actually magistrates' courts. And in response to this, we'd like to say that no amendment is required because Section 1 of the Act does define court as meaning a magistrate court. There was also another submission to say that reference to the minister in the proposed Section 34, 1A, paragraph A, Roman 2 is unnecessary and will create confusion as it tends to suggest that another person or body may make regulations. Chair, in response to that, we submit that there would be no confusion as the Act defines the minister as being the Minister of Home Affairs. And then finally, there was submission that to say that the bill should be drafted in gender-neutral language. Chair, in response to that, while there is a move to draft legislation in gender-neutral language, this bill before this committee is an amendment bill, and it's been drafted in the style of the Principal Act for purposes of consistent reading, and so that this particular section can also fit in within the purview of the full Act and the language of the full Act. And I'm sure that the department will give this consideration during its review process. Chair, that concludes my presentation. Thank you.
Thank you, Ms. Kassan. I want to check if Williams would want to add something or she's covered.
Good morning, Honorable Chairperson and Honorable members. I am covered for now. If I want to add something when we address the questions, then I will raise my hand. Thank you so much.
Okay, thank you to our legal advisors. Now I would like to note hands from members in terms of their inputs, comments, and clarity-seeking questions. I've noted Honorable Billy, Honorable Noe, Honorable Ofense, Honorable Mampuru, okay, all right. I note that Honorable Palai is appreciating all the work done from presentation, inputs, and responses. Now I would hand over to Honorable Billy.
Chair, can I just maybe show my face and switch my camera off so that I am stable enough?
Yeah, at least the country can see you that you are proper. You can switch off the video. Sure.
Chair, maybe let me just take this opportunity to appreciate the inputs that have been made by the various stakeholders, which includes members of the public who have shown an interest in helping us with this process as Parliament. And also, Chairperson, thank the Department of Home Affairs and its representatives. I think what we all appreciate, Chairperson, and understand is that this amendment bill is certainly, it marks quite a significant milestone in our country. And it is a long-awaited step towards aligning our immigration legislation with the Constitution, as it has been explained by the number of presenters citing the Constitutional Court and the process that has led us to where we are. Indeed, the bill seeks to ensure that the the arrest and the detentions of persons for the purposes of deportation are done, within a clear constitutional framework and a framework that will certainly uphold the right to human dignity, freedom, and more importantly, Chairperson, a very fair administrative justice process that will ensure that our state retains its capacity to maintain secure and orderly borders, because that is what is also very important for this department, but also for our country, especially, Chairperson, when it comes to restoring the rule of law, introducing some form of judicial oversight, and also strengthening accountability within the immigration management. Chairperson, allow me also to just appreciate the submissions which have been made, but also more importantly, the submission made by a very young man who I think deserves quite commendations, Chairperson. I think we collectively must commend the effort that he has put into this. I know many people, and most recently, who are actively seeking to change the laws of the country, but are doing it so in a wrong way, by simply being on the streets and not actively involved in these legal processes. I think we must commend when young people are wanting to be part of the legal processes and the lawmaking processes, which I would make a strong call to all those who are concerned about illegal immigration, who are concerned about the security of our borders, to make use of these processes, because this is the correct way of enhancing and ensuring that our laws speak to the needs and the concerns of the people. And I think this is the correct platform. And I think Mr. Lamont, the young man, is an example of people, citizens getting involved into the lawmaking processes that we have. So, Chairperson, I want to acknowledge the comments, which were quite constructive, but not just simply to oppose, but to also make recommendations that this committee can be able to, at a later point, look into and ensure that there is indeed a balance between what we are seeking to do and the compassion that is required, especially in this kind of a space. Chairperson, I think the last point that I just want to make, and maybe just to take into account the concerns which have been raised in the submissions, I think it's been spoken at length about the definition of the interest of justice. And I think maybe from the department side, I think there is a room for greater explanation as to how, what the meaning is going to be treated like or dealt with going forward, whether it is done through the regulations as it was explained. But I think there is certainly room for greater explanation on how we deal with that. Then, Chairperson, the issue of the language, where it says that the bill provides that detainees must be informed in their rights in a language they understand, where possible, practical and available. And I think the department has retained this conditional wording when Section 35(4) of the Constitution guarantees such communication unconditionally. Maybe there is also a bit of ambiguity in that regard, and maybe it's something that we just need to look into going forward. And lastly, Chairperson, there was an issue of illegal foreigner, the definition there. I think the explanation given that this is obviously a widely accepted term globally, but we also can't deny the fact that it does have some negative connotations. Maybe there is, maybe not this time around, because the wording is used across legislation, and I think it did say at some point that there could be a need to amend and to revisit the wording in other legislation, but perhaps it's something that at some point we'll have to look at. Chairperson. Again, Chairperson, let me end by just commending the inputs that have been put at this critical moment in our constitutional journey, and also to commend the Department of Home Affairs for its effort and encourage that as the regulations are finalized, that the department continue to engage openly, especially with civil society, with us as Parliament, so that we ensure that the implementation achieves both fairness and efficiency, especially when it comes to resourcing and the practicality of some of the consequences that will follow should this bill go through. Thank you, Chair.
Thank you, Honorable Billy. Honorable Noe.
Thank you, Chair. Just to show my face too, this is how I look like. Thank you very much.
No, you are proper. You can continue.
Thank you. Thank you, Chair, and good morning to honorable members, officials from the department and Parliament, and citizens that have taken time also to engage with Parliament processes. I think that is very much appreciated. And I will no longer be too long, Chair. Honorable Billy has covered a broader space of what we could have said as members of the Select Committee regarding the responsibility before us now of having to look into this bill. I want to appreciate the presentations made this morning, and then as well as the response by the department as well as our legal office. Chair, my comment in appreciating the participation of the public in this regard, I want to underline it or underscore it by raising an issue that actually this amendment that we need to thank the Constitutional Court in the manner in which it has raised it. That actually the Constitutional Court was definitely seeking to bring balance and recognition of the human rights as far as the people who are in this country, whether you call them illegal or undocumented, all what it is dealing with, it's people who are not South Africans. How we refer to them, it's another issue. But for me, is to highlight that all of us as South Africans, it clearly brought to our attention that people who are getting into our country without proper channels, they definitely bring to us as a country a number of challenges. But right now, as we are sitting here, it is definitely cost. And the processes that we are, we are already going through in trying to address just one person who might be in this country, having got into our country through improper channels, it is already cost. And as and when we try to deal with how we will manage this person, again, it brings a lot of costs. So this is my appeal also to our citizens, that as they consider our government seeks to deal and manage with these people, it should also be considered vis-a-vis the pressures that the people are bringing to government in terms of having to take care of them, in terms of having to deport them. We are definitely stressed as it were, because if you look at the presentations for those who are for and against and seeking to see some gray areas in terms of the act, most of them or few of them do not necessarily take into account the effect to South African citizens by the people who are in the country who came in through wrong channels. So therefore, Chair, I really want to end my submission or my comments by saying it would have been interesting if the different
recording in progress
we received this morning, if you can say to the different people who've made submissions, if they can be given a chance also to respond to one another, because that addresses what actually the young person has said about the future, because indeed what we are doing today, we are preparing for the future, and their participation now, it really seeks to make sure that the future is bright. And if they could also benefit in terms of considering each other's submission as to how will you have responded if you were in this position, that will also enhance and strengthen our consideration in the final analysis. But definitely, Chair, we really appreciated the submission that we received, and we hope for further engagement with our citizens in the manner in which they did this morning. Thank you, Chair. That's my submission.
Thank you, Honorable Peter, and as well for being foresight in terms of what can be innovations that we can use or do in terms of enhancing public participation among those who are participating in these discourses. Honorable Mampuru, then after you, it should be Honorable Mukai, because I no longer see his hands on the platform, but he was one of
I'm
those.
covered, Chair.
Oh, you are covered, madam.
I'm covered.
Okay,
Thank you. Yeah.
Okay, thank you. Honorable Mampuru.
Thank you, Chair. Can you see me? I think I can now switch off the camera.
You ask, you are permitted. You look audible and you are improper. You can continue, you can switch the video if you have glitches.
Yeah.
Yeah, thank you, Chair. Chair, I think let me firstly greet you and all members of the committee, and also show my appreciation to all the participants, in particular members of society, who took it upon themselves to come and make presentations here. Because at times, we as leaders tend to have our own way of dealing with things without involving members of society. But when it is them who comes and make their own presentation on day-to-day issues which they are confronted with, and not only make presentation, but provide clarity and advice on how certain issues must be addressed. I think that's what really democracy is. But Chair, at times speaking last after other speakers have made their inputs, it limits you because on many occasions they touch on issues which you are going to address. Chair, I had a discussion with some of the immigrants, some legal, some illegal, on issues which they are facing when it comes to deportations and factors which they raise. One will say at time deportation on itself is regressive. It doesn't resolve which we are confronted with, because they highlighted that you deport them now. As the bus drops them at the border, they automatically, with the assistance of some border management officers, they come back riding behind the same bus. But I hope, Chair, that as and when we'll be dealing with this matter, it will then have to give way of saying, how are we then going to not only deport, but assist them together with their countries of origin to document them, whether compulsory documentation, or find a way of how we can assist in making sure, enforce in making sure that everyone else get documented, so that even the skills that they will be coming with in our country will assist in growing our economy and creating employment. And Chair, the speaker, one of the participants here spoke of, I think it was Mr. Lamont, the young man, that most of them, I normally refer to them as migrant workers. They come into our country with skills which also assist in not only empowering our economy, but creating employment for our people. So as and when we will be dealing with this bill, we need to put that and bear that in mind, to saying that not all of them come into our country with some sinister motives, but they come into our country with an idea that they are going to contribute into growing the economy because of some of the political challenges which they might be facing in their own country, which might not be feasible for them to explore their skills in there. But Chair, as I've said, that we need to find a way of making sure that these immigrants who come into our country, working together with their own country of origin, we assist in making sure that they get documented and they are going to be able to, contribute into our economy. But lastly, Chair, I'm glad that the issue of children was properly highlighted here. It was properly raised on then how are the children going to be protected? Because if we don't pay attention into that, surely, Chair, we will not, as a country, because child protection is not only a matter of humanity, but is a matter which internationally has been recognized even by the UN, to say that how do you then deal with the protection of children, of the immigrants who are in your country? So I believe, Chair, that as and when we move, we'll be able to say that as a country, how do we best deal with it, and how are we going to move as we are dealing with this matter. But I must send my appreciation as the committee to say that the inputs which have been made here are welcomed, and surely they will be able to assist us going forward. Thank you, Chair.
Thank you, Honorable Mampuru. The last hand will be Honorable Nonkonyani. Nkoni, over to you.
Chair and honorable members and distinguished guests, good afternoon. I think for the first and foremost, I must join my colleagues in thanking the public participants for actually providing valuable inputs towards our goal of securing our borders and to make sure that the South Africans, particularly peace-loving South Africans, do enjoy the fruits of liberty that they fought so hard. And thirdly, Chair, I would love to make it crystal clear to all of us, including, of course, our guests, that this bill, as all of us understood, is as a direct result of the Constitutional Court quashing the provisions of the Principal Act, which necessitated, in line with the separation of powers, that we need to reconsider our stance emanating from the views that the Constitutional Court expressed, which is binding. And I must also say thank to our colleagues in the National Assembly, because it's quite clear to me that they regarded their brief, being brief as it is, to consider, Chair and honorable members, the provisions of the clause that have been quashed. And they were guarded not to extend by introducing other provisions, because that may also be taken back to the Constitutional Court and quashed again. In isiXhosa, they say, ukuthetha kuzala okunye ukuthetha. In other words, whatever we may then, by way of innovation or improving and trying to address the mischief that we were confronted, and South Africans, including, of course, the presenters today are concerned with, quite correctly, may also then lead us to another constitutional challenge. Hence, I would say the NA was correct in my view, and indeed the department, as well as our department, our legal advisors, are actually cautioning us to do that, but also indicating, which is good to us, that perhaps by way of subordinated legislation in terms of regulations, we might as well address those other concerns, which I feel it is within the parameters of the law. We're not going to be to quashed, and also bring it to our attention that certain other provisions are actually provided for in other legislation, which I believe is really empowering us. And in view of that, Chair, I would say join you what you say, that we must thank the presenters today, and thank the department as well as legal advisors for the advice that they've given. And then let us therefore mull over these things as political parties. Perhaps at the next meeting, then we come up with concrete proposal, because today we have received valuable proposals. I was excited, like you, Chair, young South African, the leaders of tomorrow, really coming up with sensible proposals, which we must not actually throw them away. We must really consider them seriously. And therefore, Chair, I would therefore commend that we, having received them, let us just mull over these things, and with a view that when we're compiling a report to be able to the SOP for adoption, we did justice to the submission that we have received, including, of course, the legal advice that we have received. Thank you, Chair. That being the case, that is only thing that I would like to say. Thank you so much, Chair, for giving me this opportunity.
Thank you, Honorable Nonkonyane. Honorable members, let me thank you for your maximum participation in these discussions today. From what we got as presentation from people who have submitted through the public participation, and as well the input from the department on giving clarity on issues that wanted some clarity from those who have done their submissions. And one has actually noted, members, that all of us, we all agree that indeed there's a need of ensuring that there's constitutionality in the whole process of this particular immigration bill. We are all agreeing in terms of promotion of human rights and dignity, and as well dealing with preventative measures to avoid the after effects as elaborated by Honorable Mampuru, that he has an experience shared in terms of how this deportation can affect other people when it's not done properly. And I think amongst ourselves, we really understand and agree that there should be system in place that are put by department or cross departments to ensure that human rights is protected and provided at all costs as we do this particular process. But one is noting as well, members, and we are very, very pleased in terms of the participation by the public organizations and individually, that they really show that stakeholder relations, it is important in terms of reforming the laws or actually reviewing the regulations and amendment. So I would want now to hand over to the department for just their comment with regards to the inputs made by members and things that they have been advised to look at as we will be deliberating before we take these particular reports to the House. And after the department, then I would hand over to the legal advisors just to conclude if there are issues that they've noted from the discussions by members. However, one thing that one is noting in all these discussions is the fact that we are all appreciating the challenges that we are faced because of illegal immigration. So there is a need that we must keep to what the bill wants to actually address, rather than deviating to something else, and acknowledge the inputs made by the department and legal advisors that other matters we would need to deal with them as we will be embarking on the white paper. I want to hand over to Advocate Malekate, and then as well Advocate Kassan from the legal advisors to just do their concluding remarks before I conclude the meeting. Home Affairs, are you still here?
Chairperson, I am here. My name is Mandla Matumisa from Immigration. I'm
All
here
right.
together with the Director General as well as
Can you see your
Advocate
face that you are not in pajamas?
Where do I click? Where do I click? There we
There's
go.
an icon of a video. Just click there. Yeah.
I've done that.
Okay. You look proper and in order. Just switch off the video and continue.
Yes. I take it that maybe Advocate and the DG are not here, so I thought I should jump in so that we don't delay the meeting. We indeed had listened to Chairperson and the Honorable
While you are
members.
still there, you must indicate to them that we don't do such. We are in Parliament and we have rules. When people decide to leave the platform, they need to indicate for the Secretariat that they are leaving the platform because of some other reasons. So just note that they have offended the rules of Parliament as you continue. Thank you.
I will definitely convey that message, Chairperson. I was saying, Chairperson, Honorable Chairperson, that on behalf of the Minister, the Director General, and the department, I think, as well as the colleagues from the legal side that have listened and received the inputs from the stakeholders and the members of society and organizations that have made inputs. I think we have heard the remarks by the members as well as the honorable members as well as yourself, Chairperson. We also appreciate the work that were done by those that have made oral representation today. And for me, when I was listening as the acting head of immigration, I felt that on matters that the Constitutional Court has brought to us, we are not far from each other. We will be able to reconcile where we need clarity and also where we need to implement the Constitutional Court orders as well as judgment in relation to these provisions. We should be able to do that. We will consider those additional comments we have noted today, and we will fine-tune with our state attorney, we will fine-tune with our legal advisors, and we'll be able then to revert back to the process to be able to take the process forward. We are aware that this is the matter that has been pending for some time and is critical to ensure that we are able to execute our mandate in terms of dealing with the matters of undocumented persons in our territory, as well as orderly migration into South Africa, as well as those that wishes to reside in South Africa with necessary documentation, and we provide that support. We wish to thank the Portfolio Committee on this matter and the advice and guidance you have provided on behalf of the department. I think those for me are the remarks that I can make in supporting the work that was done this morning. Thank you, Chair.
Okay, we thank you, Mr. Madumisa. Legal Department.
Thank you, Chairperson. Chairperson, we didn't note any questions directly for us. However, we did note the discussions that the members and the issues that the members raised and issues that the members want to take forward to the next meeting for deliberations. We'll certainly avail ourselves at that meeting and provide further assistance where we can. Thank you, Chairperson.
Thank you, Ms. Kassan. I think one is noting the chat. Actually, it's a direct chat from James. We will engage with you through the office because as we do our business, we go through as the agenda is presented. The process was made for us to listen to yourselves in terms of issues of clarity, and as well that the Department of Home Affairs and legal advisors can give clarity on other issues. But you are at laxity to actually write to us. All of you who have done the oral submissions, you can write to us through the Secretariat as well to give feedback with regards to today's session in terms of the responses being given to yourselves by the department and legal advisor, noting as well the comment from the members of parliament. So now it's my turn. One would want to echo the sentiment by members that we really appreciate your involvement in terms of public participation, and we want you to continue making sure that you participate in all these legal processions that are being called for the public by Parliament, so that we are able to draft the government business and agenda as the society at large. I want to appreciate, as members could have done, the work done by the Department of Home Affairs, our parliamentary legal services, as well as the content advisor, that indeed we didn't lose the meaning and the essence of what we were supposed to be to do as per the Constitutional Court. Issues such as legal aid, asylum seekers is one of the things that we have noted. Dealing with vulnerable groups and reasonable condition has been responded to. Constitutional concerns have also been responded to, and members have actually appreciated all inputs made, and particularly in respect of the importance of the bill in strengthening the rule of law and as well judicial oversight. As a committee, we would particularly like to encourage Thembiso Lamont, who is so young, to continue engaging Parliament and to wish him well in his exam. I wish, as the select committee, Thembiso, that in one of our programs, we would invite you, more especially for Youth Month, to come as a courtesy, to come and participate on public participation for Youth Month programs. We need to remember that there are comments that fall outside of the current bill, but will be taken on board by the department when they deal with the white paper on citizenship and immigration and refugee protection. I would like to indicate as well that as we will be dealing with white paper, as the select committee, we would consistently communicate with yourselves, those who have participated, because we had 16 submissions from the public participation process, and we only had 7 of yourselves who wanted to do oral reply, and only 6 got to actually come to this last process of public participation. So indeed, it really shows that we are not only our own as legislators, but we've got communities back up to ensure that we drive the agenda and business of Parliament. We thank all the presenters who made inputs today, and the committee will consider and deliberate further on this bill in the next meeting. So I want to say to yourself, it is important that you follow through the process up until we actually adopt this particular immigration bill from the side of the NCOP. With that being said, I want to wish you well, and I want to say, let us not forget the essence of this particular immigration bill, and so that we can uphold to the Constitution and human rights as South Africans, because we all know and understand that it is important to factor issues of mental health and psychosocial support as we deal with these issues, so that our humanitarian agenda must not lose meaning as we execute our work. We want to say to the department, you must continue engaging stakeholders at different levels with regards to these issues, so that people must not lose meaning and essence of what is it the bill that it wants to address. So with that being said, members, I want to officially thank you and officially adjourn this meeting. Nangomso. Ndiyabulela.
Thank you, Chair.
Thank you, Chair. Thank you, everyone.
Chair.
Goodbye.
Thank you, honorable members, and thank you.
Thank you.
Thank everybody on the platform.
Thank you, everybody.
Matters, we are noting your late apology by the DG. We are noting it is noted.
Thank you.
Okay, Enoch Mbau, I've noted your chat. We'll keep you in touch. James will keep you in touch. And everyone is at liberty to submit. You got the feedback, you got the response. You can submit in written responses just to get the feedback from yourselves with regards to this process.
Thank you for your time. Thank you very much.
Yeah.
Bye, everyone.
Sure. Bye.
Recording stopped.